So I'll do just a brief introduction. You have a microphone right there. So our first panelist group is from the firm. So this is a little self-representation here. We have Dennison and Shawna and Arla Cahill that are going to talk about some of the legal aspects of special needs, some about trusts and education law. So I'm going to turn it over to them and enjoy.
Good morning, everyone. I'm Shawna Brown. I'm counsel in the legal department at Mandelbaum Barrett. Thank you, Richard, for those great introductory remarks, and Barry as well. And I'm going to start off by talking about estate planning. So, estate planning is actually something that everyone in this room should do. It is not just for wealthy people. It's not just for people with a complicated family or life situation. Everyone needs to do it. It is especially critical for families who have loved ones with special needs to engage in estate planning. Otherwise, you're going to be depriving yourself potentially of government benefits and programs that you'd otherwise be eligible for. And Donnie will talk more about how that factors in. So what I'm going to talk about really applies to those of us with loved ones with special needs and people who do not. So when someone comes to us and says, I don't have an estate plan, I need one, there are three basic components that I think everybody needs. A last will and testament, most of us know what that is. That's a document in which you lay out your wishes for how you want your assets to pass on your death. Certain assets, we'll get to that. Surprisingly, a lot of people die without a will. There are famous people who die without wills. Yesterday I was talking to somebody about Prince. He was this incredibly famous person, had lots and lots of money, and died without a will. And if you do die without a will, your estate will pass in accordance with state law, which might not be what you want. Think about it. What if you have, someone that you never married but lived with for a long time, you don't have a will, you pass away, and it goes to, nieces and nephews you haven't talked to in 20 years. So this is critically important. A will is also a vehicle where you can set up trust planning, which Donnie will talk more about. I'm going to step on your toes there. But you can set up a vehicle to provide for a special needs loved one so that they're not going to be disqualified for their government benefits. The next component is a power of attorney. That is a document in which you designate an agent to make primarily financial but some personal decisions for you in the event that at some point you're not able to do that on your own. There's two types, a durable and a springing, or really an immediate and springing. A power of attorney can take effect immediately, or it can be springing, meaning it only takes effect if something happens to you and you no longer have capacity to make your own decisions. The third component, a living will, is a document where you designate an agent to make medical decisions for you and also have access to your medical information. That's very important. You can also lay out your end-of-life wishes, such as do you want to donate organs? Do you want to be kept alive artificially? Do you not? Things like that. So one critical thing is, I think a lot of people are under the misconception that people with disabilities of a cognitive nature can't execute these documents. Sometimes they can, but a lot of times they can. So for someone who is able to understand the meaning and significance of, say, a power of attorney and a living will, that's of critical importance. And a lot of parents are surprised to learn that once their disabled child reaches adulthood, they're no longer legally their decision maker. They think, oh, well, they can't do that, so I have to keep doing it. Well, you do, but you need something legally to enable you to do that. So if your child is able, that's why it's critical to, to explore signing these documents. So what happens to your assets when you die? So like I said before, there are certain assets that pass under your will, certain assets don't. So the assets that pass under your will are your probate assets. So those are assets that you own individually, not jointly with anyone else, and that do not have a named beneficiary designation. A non-probate asset does not pass under your will. Whatever your will says, the non-probate asset does not pass in accordance with that. Those pass outside of your will through a joint ownership designation or a beneficiary designation. Can anybody think of any examples of a non-probate asset?
Life insurance.
Good. Anything else? Yeah. Right? Yeah, so that could be a bank account that names a joint owner, an IRA, a life insurance policy, a brokerage account that names a beneficiary. It's usually a good idea to have your distributions under your will and your beneficiary designations to be somewhat in line, so there isn't confusion or issues or fighting later. But it's important to understand the difference between those assets and certain assets in particular, you know, a life insurance policy or an IRA. It's really critical to name a beneficiary for those assets. All right, so this is just a further list of what different non-probate assets are. Property held in trust is also not probate. So if a person has established a trust during their lifetime, or one to take effect after they pass away, that is not going to pass under your list. Okay, so a trust, what is a trust? A lot of people hear the word trust and think that sounds really complicated, like, oh, trust, that makes everything harder. It really doesn't. A trust is almost, I think in my mind, is just a contract that lays out what you want to happen to an asset. That is not a will. Do you need a trust? Some people need a trust and some people don't. I know that like Susie Orman is on TV saying, everyone needs a trust. Well, okay, everyone can have a trust, but you don't always need one. Instances in which you may need one are for tax planning purposes, especially if someone is very high net worth. There are tax strategies that can be incorporated into trust to save money, to avoid probate. So when someone passes away, if they have probate assets, their will needs to be admitted to probate. And that's a court process. In New Jersey, it's starting to take a little bit longer than it used to, but it's not anything like New York. If you have clients or loved ones in New York, then please do a trust because God help you. But some people want to avoid probate to expedite the administration of their estate and their assets, or just for privacy reasons, like they don't necessarily want to share copies of documents, and probate may have to do that. A spendthrift beneficiary, so if somebody has a relative that isn't good with money or is just spending like crazy, you may want a trust set up for them so someone's controlling their spending. That also could correlate to someone perhaps with a cognitive disability who perhaps doesn't have the ability to understand or manage money. So someone could do that for them. For minor beneficiaries, because you can't just leave a child, $100,000. So a trust can be established for someone to hold the assets for them and manage them until they reach a certain age. Second marriage, blended families, if you're part of that, it's a good idea to have trust planning so you can provide for your spouse. And then also have a provision where after your spouse passes away, your wealth will pass to your children. Or for Medicaid planning, which we'll talk much more about during this program, it's also critical to preserve eligibility for Medicaid. Okay, so what are our takeaway estate planning tips? Plan, plan, plan. It's critical to enable loved ones or trusted individuals to take action in a crisis. It's so important. So, for example, if somebody does not execute a power of attorney or a living will, and they have a crisis where they no longer have the ability to make their own decisions, if they need a decision maker, you have to go to court to get a guardianship for that person. And that's an expense and can be a time-consuming and potentially emotional process if it's contested in some way. So doing estate planning documents will avoid that. Ask questions. It's so important to ask and just to do the process. This kind of ties into number 3, hire counsel, that the initial investment in an attorney can save you thousands in the long run. A lot of people come to me and say, I haven't done an estate plan, it's so complicated, I don't want to do it. And they come to me like, they emptied out their entire file cabinet in their house and come to me with that. And I say, it's really not that complicated. We just need to talk through what your wishes are and ask some questions, and then we tailor the plan for our clients. And other attorneys will do that as well. So it's so important, I think, to have an attorney on your side. The downside is that if you don't prepare the will properly, it's not executed properly. I've dealt with cases where we have to go to the court and file complaints with the court, just a litigation, and say, oh, this wasn't witnessed properly, so now, we're spending tens of thousands of dollars dealing with the case. So it's so important, and for families with loved ones with special needs, it's so critically important, because if you don't do an estate plan, you're missing out on a lot of benefits.
Morning.
Chuck, you were dying.
Can you hear me all right? Zena in the back, can you hear me okay? You're the Three Musketeers? All right, good morning. The reason I'm so conscious of whether you can hear me, especially in the back, is last year I had some of you may have had the pleasure of witnessing my continent when I was speaking, and I had a handheld mic. No one could hear me in the back. So this year I've got water in the cup, not coffee, to dry my mouth out, and I have a lapel microphone. No. All right, good morning. I want to just go back for a second to one of the comments Shawna made about estate planning, the importance of estate planning, and how it can potentially avoid court intervention, especially for those folks who have special needs, who may not need to go the guardianship route or the conservatorship route. A guardianship, as some of you know, as many of you probably know, is a very restrictive, again, court-imposed protective arrangement in New Jersey. And that's a lowercase p, lowercase a. There's a protective arrangements that are in the statute, which I will refer to as our uppercase p and uppercase a. Before I get to that, guardianships generally, and even protective arrangements or conservatorships, deal in some way, shape, or form with stripping of certain rights, fundamental rights of an individual. And so oftentimes in these special needs groups, attorneys, elder law attorneys, special needs attorneys, oftentimes the first instinct when they're dealing with someone who is reaching adulthood is to recommend a guardianship, and I think that is dangerous. Again, I think paramount importance is to respect the dignity of people's rights and choices, even those with disabilities. And so I'm going to go over these court-blessed, court-sanctioned arrangements today because they are often encountered, but I just want to reiterate what Shawna said. Oftentimes those less restricted means of helping folks should be explored first. So in terms of the guardianship work that we do, we handle on a daily basis, we're dealing with court actions to have a person either appointed guardian of another person or guardian of their property or both. The guardian of a person being someone who makes medical decisions, reports with respect to their ward's well-being, that oversees their medical care, treatment, doctor's appointments, etc. Guardian of a property being a guardian over someone's finances, over their estate. Sometimes you'll hear guardian of the property referred to as a guardian of the estate. And a limited guardian. A limited guardian, circling back for a second to what I was just mentioning about respecting certain rights, certain dignities of a person. Maybe they don't require a full plenary guardian over their person and property. Maybe he wants to carve out certain rights. Maybe that the alleged incapacitated person feels strongly about voting. You can have a limited guardianship that would enable the individual to continue to vote. And so how do we get to the guardianship point? We have to file a verified complaint in a superior court, the county where the alleged incapacitated person resides, alleging incapacity by virtue of disability, mental incapacity, and we have to support that verified complaint by the submission of either 2 doctor's certifications, or in the case of a DDD guardianship, which is a special type of guardianship that can be filed in New Jersey, with a IEP or 1 doctor. And Arla will be talking a little bit about IEPs. Once that complaint is filed, supported by the doctor's exams, the IEP, the court will then appoint an attorney for the alleged incapacitated person whose job is to represent the interests of the alleged incapacitated person. I want to distinguish that role from someone who is appointed a guardian ad litem guardian ad litem has to represent what is in the alleged incapacitated person's best interest. But here, again, respecting the dignity of the alleged incapacitated person, the court-appointed attorney's job is to advocate for the alleged incapacitated person's wishes, so long as they're not patently asserted. If the court-appointed attorney is being instructed to contest the guardianship, they will file an answer to the complaint, and there will be a guardianship contest. However, if there is no viable defense that can be mounted against the guardianship, and the court-appointed attorney, perhaps they've spoken to their client, and their client says, no, I really do need some assistance, that the guardian would be useful, and I don't mind it's the person who is seeking the guardianship, then a report will be filed, and the court will hear the guardianship case and appoint a guardian most likely. All of this to say that a guardianship is a court process that can take time, it can be very expensive, and in some cases can be avoided.
And just to make everyone aware, in a will, you can appoint a guardian for a minor child, but you cannot legally appoint a guardian for an adult. That can only be done by the court, so that's an important consideration.
It is, and another consideration piggybacking off of that is oftentimes people believe incorrectly that by having a testamentary guardian appointed in their will, that testamentary guardian is automatically going to be appointed if something were to happen to them. They still have to go through the testamentary guardian, still has to go through the qualification process and the vetting process. The court still has jurisdiction to ensure the safety of the incapacitated person.
Right, and if, let's say, someone has their parents as their guardians and they're getting older, there isn't automatically like a successor that's appointed by the court. You actually have to go into court and ask for someone to be appointed, so that's an important consideration.
Sure. I'm just going to run through these two last types of protective arrangements very quickly. They are less restrictive in terms of stripping a alleged incapacitated person or a person with disabilities in the case of a conservatorship, stripping them of their rights. With a conservatorship, it requires the consent of the conservatee, the person who is subject of the conservatorship. And in New Jersey, at least, even though you may hear about conservatorships in other states like California with Britney Spears, in California, the conservatorship looks a little bit more like a guardianship in New Jersey. In New Jersey, it's very distinct in that the conservatorship is really just a court-appointed individual who oversees the management, care, upkeep of an individual's finances. It's limited to finances. Has nothing to do with the well-being and health of the conservatee, and the conservator is oftentimes a family member. Just jumping to protective arrangements, again, a less restrictive form of assisting someone who has to be alleged, at a minimum alleged, to be incapacitated. We need the 2 doctors' reports in order to get into court under a protective arrangement. And typically the protective arrangement is being sought because there are one or at least very, very limited circumstances or situations that need to be dealt with from a financial perspective, even a care perspective. It's something, if there are allegations of malfeasance and a family member or loved one wants to step in, they may file a protective arrangement, especially if they believe they can't get 2 doctors' certifications to support a guardianship file. So oftentimes it's like a stepping stone. It's the first step to getting to guardianship. And we've used it for that purpose before because it's part of the process for applying for a protective arrangement. The court must appoint a guardian ad litem, best interest, and that guardian ad litem may recommend that a guardianship be filed. All right, so I mentioned the process already, so I'm going to run through it for a guardianship process. You have your verified complaints submitted alongside the 2 doctors' certifications or the IMP doctor certification. You have that court-appointed attorney. Again, interests, wishes of the alleged incapacitated person, major factors are time and cost, of having to go through the guardianship process. And the DDD guardianship statistician, your ability to file for guardianship without 2 doctor certifications, called 1 doctor certification, plus the IUP. In terms of what is expected of the guardian after they are appointed, there are almost always reporting requirements, either 1 or 2, those being annual reports of the finances. It's typically in the form of an accounting, and there are different types of accountings, right? You can render an easy accounting, very simple accounting, simply bank statements, essentially, or a more comprehensive accounting, and what's typically determined is how much money is involved, how much money the incapacitated person has. And then there's the annual report of well-being, reporting with respect to the health and healthcare of the incapacitated person, and that has to be submitted alongside an annual doctor's form certification. And these are typically required on an annual basis. All right, I want to talk a little bit about special needs.
Don, before we move to special needs,
Sure.
can you talk a little bit about what parents of young adults with disabilities need to consider? When should they consider a guardianship? How early before a child turns age 18? What happens when the child turns age 18? And some of the thought process for folks going through that. And can people do it themselves? Is there ability to, do you always need a lawyer, or can they do it themselves?
Sure. So, in terms of what age a parent should start considering the guardianship, the guardianship is really only going to become a factor once their child turns 18. And so, if a parent has a child with special needs, perhaps, and they believe that their child is going to really benefit from a guardianship, whether that's a person, property, or both, they should start considering and speaking to professionals, whether it's a lawyer or someone else. They should start speaking with those people prior to 18. It's a bad situation when you were just starting this conversation at 18 or over the age of 18, because typically you have been scrambling to get these things done. Again, time and cost, it's a huge factor.
A lot of families start about 6 months before they turn 18, and I find that that's
Even a year, yeah. I think even a year is appropriate. And so one of the major considerations, I think, for parents in that position that they're faced with is whether their child can sign power of attorney in a later will. Maybe their child is going off to college. If they're going off to college, strongly recommend at least a conversation with a lawyer about their child signing power of attorney or a living will. But in the event those have not been executed, perhaps as a result of the incapacity or alleged incapacity, we should get the guardianship conversation started. Your question was, does the court always appoint it? Okay. Yeah. Okay. Yeah, so his question was for whoever didn't hear, does the court always appoint an attorney to serve as the court-appointed attorney? The answer is yes.
To serve as the guardian.
Okay, to serve as the guardian, not necessarily. The court may, in certain situations, appoint an attorney to serve as a person's guardian if they don't have any family members or loved ones who are capable of serving or willing to serve as the guardian. In those cases, depending on the circumstances, the court may appoint an attorney or another professional to serve as the guardian. Typically, a guardian ad litem is an attorney. That's the individual responsible for advocating for the best interest of the alleged incapacitated person. And they're typically attorneys, but they don't have to be necessarily. In terms of the start date, when we're thinking about guardianship and the conversation that we should be having, again, a year, 6 months prior to the child turning 18, let's explore those less restrictive options. power of attorney of the living will. And if we have to go the guardianship route, then we want to start involving a team of people, right? We want to involve the doctors, those who provide medical care services for the child soon to be adult. We want to involve their school, right? We want to get the most recent IEP so that we can file a PDD guardianship. We want to start gathering these things together because it's sort of unbelievable how long it takes to do those things. Just getting the doctor's report, getting the IEP in order, the most recent IEP in order, submitting those to the court, and then waiting for the court to enter that order for hearing. Getting to the order for hearing can take quite a lot of time. So being proactive is really important. And I think 6 months to a year at a time is pretty good. You don't have to hire an attorney to file a DDD guardianship. In fact, a lot of organizations, DDD itself, will provide guidance with respect to filing for a DDD guardianship, filing for guardianship. Certainly, a lot of organizations encourage people to file for a guardianship for their disabled child, soon to be an adult. Again, it can be a little bit problematic. The knee-jerk reaction is to file for guardianship instead of considering less restrictive alternatives. But there are organizations out there that can assist people, at least providing the information necessary to file for guardianship. You don't need an attorney. An attorney can be very useful, especially for that post-guardian appointment work, the reporting, if you have questions. Sometimes it's really useful to have that attorney who's familiar with the case to guide you through the manual reporting requirements. In terms of the special needs trusts are really good considerations for parents, for disabled individuals, in order to protect government benefits. In terms of the waivers of special needs trusts, we have a first-party special needs trust, sometimes referred to as a D4A trust, and we have a third-party supplemental needs trust, sometimes referred to as a supplemental benefits trust, but it's a third-party trust. In other words, it's not the disabled individual's money that they are funding the trust with. It is a parent, a loved one, someone else's money that's going into the trust. And this is an important distinction because in terms of the requirements, the language of the trusts, what you can do with the trust reporting, they look very different. Even though they function in a similar way in terms of protecting and preserving government benefits, not the money in these trusts are not considered assets that are deemed to the disabled individual. So for Medicaid, for instance, or SSI, needs-tested benefits, we don't have to worry about the money in these trusts being considered as assets. Right? In terms of the first-party special needs trusts, these are very closely monitored by the state of New Jersey. I'll give you some examples of the requirements and distinguish them with third-party supplemental benefits trust, supplemental needs trust. For one, the first-party special needs trust, it needs to be funded by the assets of the disabled individual. Perhaps the disabled individual is involved in a car accident. They go to Eddie Browsick in our office. He deals with the personal injury action. He wins or he gets a settlement and he pays. That settlement money, we want to protect that settlement money from Medicaid so that the disabled individual is no longer at risk of losing Medicaid benefits by coming into this money. We may decide to put this money into a first-party special needs trust. First party because it's their money once they come into the settlement. Once the money is in the first-party special needs trust, the beneficiary of those funds cannot be the trustee over those funds. They have to be the sole beneficiary of those funds. The money in the trust is reported every year to the state of New Jersey, to Medicaid, who keeps a very close eye on the trust. And in terms of the disposition of the trust money after the death of the primary beneficiary, the sole beneficiary, the state of New Jersey, the Division of Medical Assistance and Health Services has to be named as the primary beneficiary of that money in order to repay Medicaid what Medicaid had paid out to the disabled individual during their lifetime. Very quickly distinguishing that from third party supplemental benefits trust, supplemental needs trust. That money that is funded into the trust is a third party's money. That third party is often able to dictate where it should go after the death of the beneficiary, so it doesn't have to be repaid. There's no reporting requirements associated with third-party supplemental needs trusts. And in terms of having to report as to specific transactions, first-party special needs trust, oftentimes, any transaction of 5,000 or more needs to be reported ahead of time, or you have to sort of seek permission from the state before making a transaction of 5,000 or more. Third-party supplemental benefits trust, no such reporting requirement. And so it's a lot more frequent.
And that's why you or your clients really need to do an estate plan, because then you can set up that kind of trust,
Right.
and everyone just seamlessly tests into it.
And even if the disabled individual is not considering for on Medicaid SSI, just to keep that available.
It's like a shell, it's just there when you need it. That's the benefit.
We went through these slides that will be available for everybody. And obviously, I touched on it for a second there, but the overarching sort of purpose of the third-party supplemental benefits trust and first-party special needs trusts is to preserve government benefits needs tested, like Medicaid, like SSI, and Medicaid. Obviously, we're going to have a really interesting discussion on this later with Arla. Disability rights in New Jersey, but Medicaid will provide health services to individuals who qualify as long as they meet sometimes income eligibility requirements, sometimes both income and asset eligibility, sometimes income, asset, and clinical eligibility requirements. But the special needs trusts are really meant to preserve money for the disabled individual's benefit without throwing them off Medicaid. We sure have. Yeah. Mimi's question was, is Medicaid's look back 3 years still, or is it up to 5 years? The look back she's referring to is essentially an audit of a Medicaid applicant's financial history for a period of 60 months, 5 years, to determine whether there has been a gift of their assets. If there has been a gift of their assets, a transfer of their assets for less than fair market value, then impose a penalty. It is now 5 years in New Jersey. It has been for a while. And New York is still 5 years.
Just a little technical clarification there. Good morning, everyone. My name is Arla Cahill. Can everyone hear me as well? I'm not as accustomed to holding a microphone and clicking at the same time. I'm the chair of the Education Law Practice Group at Mandelbaum, Barrett. Education law is a passion of mine for more than 25 years. I first started out with school districts, and then when I joined Mandelbaum, Barrett almost 21 years ago, I started representing families, and that's where I think it's really key that families understand what their rights are. So whenever I get a chance to advocate or educate families, I am very pleased to do so. So thank you for being here today. I'm going to give you a quick overview today. I'm going to move fast because I didn't get the memo that I should have only a few slides. I have like over 30, but I'm going to go very fast. And you will have these materials for your reference and certainly available to answer questions. One of the big questions that I have as a lawyer from clients is, what's the difference between 504, Section 504 of the Rehabilitation Act and the Individuals with Disabilities Education Act? I'm not going to get deep into 504, but I just want to say that there is a difference, and and it's essentially a civil rights act. It's an anti-discrimination federal statute that does apply to schools, public schools, and in some instances, public employment in the federal context. There are some differences. I'm not going to go through all of them, but 504 is basically equal access to programs, services, and buildings. You know, it's seen as like accessibility versus education. We actually have some content on our law firm's YouTube channel where I have a video that I discuss the differences in a little bit more detail. So you'll be able to check that out by Googling. The Individuals with Disabilities Education Act, also known as the IDA, is an education statute that's applicable to all public schools. Each state has adopted some version of this federal statute. And just for a visual here, anyone who is eligible for educational services under the IDA is also protected by Section 504 of the Rehabilitation Act. And of course, then you have regular public school education, assuming that those students are typically developing and without disabilities. So the question is, what is special education? It's specially designed instruction. It's a modification of curriculum due to the student's disability. It's designed to meet the unique needs of the student, so that is kind of an unusual statute in which every student gets an individually tailored education plan called an IEP, an individualized education program, which is different from your regular public education student who gets a one-size-fits-all education generally. It's also provided special education is in the least restrictive environment, the LRE. That means to the maximum extent appropriate, the student is going to be educated with regular education students, typically developing peers, with supports. And I'm going to discuss in a few slides down as to those situations when we look at the LRE analysis. Some students, because of the nature of their disability and the need for more significant supports, may not be able to be educated in the regular education setting. The other important component of the IDA's protections, the services that are required of a public school are free to the parents. So who is entitled to special education? I'm often confronted with the question from members of the public or clients, because they may not always know that all public school children with disabilities from age 3 through age 21 or high school graduation. So obviously that is a greater age range than your regular education student. So in public schools, there's a concept called FAPE, Free Appropriate Public Education. And every school is required to provide FAPE, which is the subject of a lot of litigation. And what does that mean? Well, the recent articulation by the U.S. Supreme Court is that it's education that is intended to give meaningful benefit, educational benefit to the student to maximize their potential. Of course, that in and of itself is subject to interpretation. So it's the University, I think, is at the forefront of determining what is FAPE and giving appropriate educational services to special education students. But we become involved when those school districts, unfortunately, are not meeting that standard. So free, appropriate public education, as you see here, the definition, educational program, and related services, which I'll mention what those are in a minute, are individualized to the student, specific student, and meets the standards established by the state and provided without charge. Least restrictive environment, another concept that is the most misunderstood and misapplied by school districts, unfortunately. It does not mean, well, let me just tell you what it does mean first. Least restrictive means that to the maximum extent appropriate, school districts must educate students with disabilities with regular education students. It's very important to distinguish that from maximum extent possible. Possible is not in the statute, it's appropriate. So a student who is not appropriate for a regular education classroom should not be in that classroom. And it's not a punishment, it's not punitive, it's really what's individually tailored for the needs of that particular student. I'm often consulted with by parents who want one of two things. One, they either want their child in the regular education class, and that's a fine goal if it's appropriate, or they don't want their child in the regular education class, and that may be appropriate too. But again, we look at the individual needs of the student. So how do we even get here? How do we understand whether or not the student is a student who needs educational services? Well, we have a doctrine known as child find. School districts and medical professionals and others have a duty to report to the local educational institution that there may be a child who needs special education services. So it's done by way of a referral. And that referral can come from a number of folks. It can come from parents, school personnel, agencies, medical doctors, Department of Education in New Jersey. So what's the first thing that we need to do here? Really important, and it's often a critical part of the whole process that parents miss. They'll call up their local school, they'll speak to somebody on the phone, and they'll say, I think my child has an educational disability, what should I do? That's a phone call. Sometimes that goes somewhere, and the public school will advise the parent to send them a letter and advise them what the suspected areas of disability are. But there are times, and that's when we become involved, when the parent makes that verbal request, never puts that request in writing, or the child is in school. So I was talking about a situation where the child has not been enrolled, but if the child is enrolled, and as time progresses, the parent suspects the student may have an educational disability. There are many times where parents are lulled into kind of a false security by the teachers, or very well-meaning individuals who just say, well, let's just see, one more year, let's see if it's a maturation issue, and don't really do anything. And those are critical years in the early part of the child's education to get services if that child needs services. So critical, it must be in writing, the request for an evaluation as to all areas of suspected disability. So, under the IDA, there is a very specific timeline. This is designed to protect families. And it's so highly technical that a lot of times families and schools do not actually follow these timelines. So it's really important, and I'd like to educate families about what they need to understand. So within 20 calendar days of receiving the referral, the school district has to hold a meeting to decide whether or not to conduct evaluations and if so, what types of testing are going to be necessary. And if an evaluation is not going to be conducted, then maybe this is a student who needs other types of interventions in the class, but not necessarily evaluations to determine if special education services are required. So the other thing that is very important, the 20-day time frame excludes school holidays, but does not exclude summer vacation. Another common misconception I hear is that we're closed. We closed on June 30th, sorry, we'll see you in September. Not true. These are, again, critical time periods, especially if it's a very young student. We need to get them services, we need to get them identified, and it's important that the school district be held accountable. So there's no wait list. It is mandatory. You cannot say, sorry, we can't help you. The Child Study Team, so CST stands for Child Study Team. It's a group of professionals, such as your learning disabilities teacher consultant, your school psychologist. It could include what's called related service providers, such as an occupational therapist, a speech therapist, physical therapist, and other types of highly specialized individuals who provide support for the student's education. They will be part of the child study team. They have to conduct those evaluations 12 months a year, excluding holidays. The other misconception is if the child has been in school for some time and is getting some intervention services, that's fine, but it doesn't have to be the case. So there's no sort of pre-qualification to get services under the IDA. So the scope of the evaluation, I mentioned all areas of suspected disability. So if the student is having trouble with reading, that suggests that that's a suspected area of disability. There may be many other types of disabilities that there's a suspicion that that student may have it. Generally, good practices that the school district will perform what's called a comprehensive child study team evaluation, and will evaluate the student with the LDTC, the Learning Disabilities Teacher Consultant, the school psychologist. They'll do a social evaluation, and there may be other evaluations if the student has some physical disabilities. The other important component here is that many times parents who know their child well have already gotten private evaluations. That's fine, and those should be considered by the child study team, keeping in mind, of course, that medical professionals are looking at the child's disability from a different standard. Educational professionals are looking at the child's disability from an educational perspective. Those are not necessarily similar or same standards, so that's very important. I will have parents come to me who have medical issues, and the physician or the medical professional treating that student may make certain recommendations, but these are not necessarily always recommendations that can be implemented in the school or are required to be implemented by the school district. So that's an important component to discuss with your attorney, should that be an issue. So another important time frame, and this is often abused by public schools, and I don't know if I can bash in public schools. I'm just saying that the only reason why we become involved is because something went wrong. So I'm giving you kind of the worst case scenarios here. The district has 90 days from the date of the parent's written consent to evaluate the student, determine whether the student is eligible for special education and related services, and if eligible, develop and implement an appropriate IEP. I've had sad situations where parents come to me and it's years later and they have not had an IEP developed because they've been sort of struggling along. That's really, really sad. That's why I really enjoy these opportunities to educate. So the requirements for eligibility for special education and related services. So just a sideline with related services, these are services that enable the student to receive educational benefit from their program. So let me give you an example. A student who has fine and gross motor skill impairments is going to need an occupational therapist to provide them with services during the week, the school day, so that student can learn how to grip a pencil or use chalk or crayon and other manipulatives that are necessary for the student to benefit from their educational program. Importantly, the disability must adversely affect the student's educational performance. Surprisingly, you may be surprised to know that not all students with disabilities are eligible for special education services if that disability is not adversely affecting their educational performance. The student must also be in need of the special education and related services. These are the 14 eligibility categories that are recognized under the IDA, and New Jersey also recognizes them under the administrative code. The ones that we see most often are autistic, communication impaired, emotionally disturbed, multiply disturbed, preschool child with disability, specific learning disability that typically refers to students who may have dyslexia, which is another hotspot for school districts because they don't ever want to provide services for dyslexic students. So it's one of those areas where we are often called to fight for the rights of the family. So we want to prepare the IEP. We've determined through the child study team evaluations, we've had an eligibility determination meeting, and now we're ready to prepare an IEP. So an IEP is very similar to a contract. Everything that's in it has to be done. If it's not there, it's not enforceable, just like a real contract can be. So we want to make sure that we get it right the first time. So we're going to have an eligibility determination meeting, first to determine the student's eligible, then immediately move into, same day, same time, we're going to move into an IEP development meeting. IEP is written, and it's going to set forth the programs and services that are required for this student, that are individually tailored to the student. So again, we see, as lawyers who represent families of students with disabilities, that many times the IEPs are not, do not contain all services and programs related services that the student needs. So the types of related services also can include counseling, occupational therapy, speech language services, also for emotionally disturbed students who have been diagnosed with a clinical diagnosis of emotional disturbance. Those students may need, I think I'm getting what Tani had last year. Those students may need counseling and other types of mental health supports throughout the day. And that, again, is to enable that student to meaningfully benefit from their education. Something else that becomes a bone of contention with school districts is extended school year. Extended school year, the purpose of that is when a student has a disability such that over the summer they're going to regress in their skills, that student needs an extended school year. An ESY is basically a program that's half a day and has like half of the services and programming that the student would normally have during the regular school year. Purpose is to keep that student's skills refreshed and hopefully get them through the summer. So it typically starts July 1 and ends like July 30th. August is the break. Implementation of the initial IEP has to be done with the consent of the parent. Least restrictive environment, I included this slide so that you can see that it's on a continuum. So students who have a lesser degree of disabling condition and with supports can be educated in the regular classroom, that's the least restrictive environment, all the way to residential. So in between there you have inclusion with supports. You have resource room, which is basically like a pull-out where the student goes to a class separated from regular education peers and given services related and individually tailored to the student's disability to enable that student to benefit from their educational program. Separate schools. I'm going to talk about that. That's out-of-district placements. Oftentimes, parents will come to us and they've heard a little bit about out-of-district placements and they believe that those placements may be appropriate because they've been told those are private schools. They are private schools sometimes, but those private schools are not college prep schools. They are schools that are specifically designed and approved by the New Jersey Department of Education to provide special education services for students who are so severely disabled they cannot be educated in the regular education school district or regular education class in their neighborhood school. So they need much more significant supports, and therefore those students would be eligible for an out-of-district placement, which is again paid for by the public school. That can include the approved private schools for students with disabilities. The list is actually on the New Jersey Department of Education website. And I'm also giving you the contact information if you have questions about that. Also, it could include programs that are operating within the district. Within the last probably 5 to 10 years, school districts are bringing in-house specialized programs that are in the neighborhood school, but they are almost entirely self-contained. So you'll hear words like multiply disabled class, autistic class, words like that, and that refers to special programming within the public school district, but it's more contained because it's only, mostly I should say, disabled students. And then we have schools with residential components, and those are for students who have typically very clinically devastating either illnesses or mental health disorders. IEPs are reviewed annually, every year, but they also could be reviewed more frequently in the event the student has a change in the disabling condition that provided their eligibility. So sometimes we'll see students who were diagnosed perhaps with autism and their classification for eligibility is autism, but they then, as they mature, they may have some other disabling condition that may be necessary to modify the IEP to include additional supports for that disability. Denial of eligibility, that does occur when the school district believes that the student's educational performance is not impaired by the disability. So when that happens, they have to file basically litigation to litigate it. It's called due process. I'm not going to get too far into what the litigation is, but it's important that it's very time sensitive. So what's very important, again, another important time frame, within 15 days of receiving an IEP that the parent disagrees with, they have to file due process. The New Jersey Department of Education has set up a very nice system on their website that has a form that parents can fill out and parents can represent themselves, although they're at a little bit of a disadvantage because the public schools, of course, going to be represented by, legal counsel. One other concept I just want to leave you with is the stay put doctrine. So what happens is when litigation is filed, the stay put doctrine is invoked, and that means the last agreed upon IEP is going to stay in place until the litigation has been resolved, either by a judicial decision or a settlement. Part of the due process petition process is mediation. So there's always this effort by the office. So this all happens at the Office of Administrative Law. There's always an objective by the OAL to mediate and get this settled, because everyone recognizes, again, time is not your friend, so we want to get these disputes timely resolved. Litigation is not very fast, so the best way to get through it is mediate the disputes and try to settle if possible. Just a little bit about due process, I won't go into that, and that is it. So I thank you for your attention.
We want to keep things moving. Just a couple of things to tie together before we get our next speaker. So one of the things you're going to hear a lot about today are supplemental needs trust and special needs trust. This is critical because people that are on government benefits, and most individuals with disabilities require some form of government benefits. A lot of them are needs-based. They require SSI in order to be affiliated with the Division of Developmental Disabilities. You have to be Medicaid eligible. So these all have these resource standards. So in order to make sure you preserve these standards, you need these trusts in order to protect the assets, as Donnie was talking about. And it goes hand in hand with some of the things that Shawna was talking about, is that you have to make sure the beneficiary designations are clear and are accurate. The biggest mistake I see people make is they do not appreciate and understand the fact that beneficiary designations supersede a will. So if you have a will that designates a supplemental needs trust as a beneficiary or as the recipient of an inheritance for a child, that's terrific. But if your beneficiary designation does something different and just names the child correctly or names generically children, that is going to pass outside of the will. So it is critical that all of these things are tied together with a nice bow. So you need to know about special needs trusts. You need to know about beneficiary designations. You need to know about government benefits. So you take all of these elements and you put them together and make sure you have a team to discuss them. So we're going to hear a lot about special needs trusts. Now the questions are, by the way, I'm not going to be giving introductions to everybody. You all have a resource journal. So everybody's introductions is in there. We're not going to take time for that. Everybody's wonderful. I'm grateful they're here. Also, we have resources in there, so a lot of the things that people are talking about, they're in the back of the journal, so you can check out those resources. So moving along with the theme of the supplemental needs trust and special needs trust,